try to stay focused on your question. In terms of how it occurred in the past, I'm not familiar with the appeal you're talking about, but I assume the appeal you're talking about was by a landowner adverse to the city. The landowner's attorney captions that, names the parties, and it sounds like an instance you talked about, misnamed the BZA as a party when they should not have been.
But the point, the difference in that case is that the city's interests were aligned with the board's appeals, so there wasn't really, it didn't seem like there was any conflict, but for the city attorney to be representing both. That's why every pleading starts out and comes now the city, city council and the board of the zoning appeals by council.
Understood. There's no adversity between your interests, because when you look at two interests, and that's what the starting point. The city's interest is in obtaining the reversal, sustaining the director's decision. That's not the BZA's interest. The BZA's interest is established by the statute, and the statute says the BZA has an obligation to do certain things. And on that issue, there's no adversity. To the extent the BZA wanted to consult counsel, there's no adversity between your obligation or your desire, I'll say, to consult counsel on what is the record and when do we transmit it, which is all that's required.
We felt naked with respect to this.
I understand. And I think it's fair. The BZA can ask those questions of the city attorney because there's no adversity between the tendering of an answer on what's the record, when does it have to be provided, and the city's interest, which is on the substantive issue.
So when it comes time for us to file the record, is the city attorney's office comfortable in filing that record and entering an appearance on behalf of the board of zoning appeals?
Well, they would file the record. They would not, in that case, the BZA, I believe, was a party. But they would not, I believe, I'm sort of speaking ahead of where Jim is on this, but they would not enter appearance because you only enter appearance for a party. By statute, they're not a party. By caption, they're not a party. In that case, whatever that case is, one procedural way to fix that would have been to move to dismiss or strike the BZA because they're not a proper party under the statute. That didn't happen. I can't speak to why, but this case needs to be done correctly, and the BZA is not a party. The BZA should not enter an appearance, and the record should be transmitted, and what the statute, I believe, requires a certification from the BZA. Staff would compile it, it would be submitted to the circuit court, and that would be the end of the analysis. But there's no adversity to the extent the BZA has a question on when do we tender it, or what should the record include. There's no adversity between the provision of that advice and the city's position, which is on the substantive issue.
And to answer your question, Mr. Allen, yeah, we feel comfortable with that because what would happen is staff would prepare the record and we would have a transmittal letter saying, here's the record on behalf of the BZA.
Filed by the city attorney?
Yes, yes, sir. Because again, as council has indicated, there is no adversity. There's no.
I get